Good morning. I hereby call to order this sixth meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As a reminder, please take note of the safety information on your agenda. Our first matter for this morning's meeting is the approval of the minutes for March 15, 2018, and I recognize Commissioner Sweet, who is the editor.
Madam Chair, thank you. I've reviewed the minutes of the public meeting of March 15th, 2018, and move they be approved as submitted.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any further discussion or edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now we move on to today's agenda. I will call up Cheryl Walker-Davis, our Director of the Office of Special Assistance, who will lead us through today's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
Good morning.
Madam Chairman and Commissioners, first, I'd like to acknowledge the presence of some very special guests today. Many of you are aware that several years ago, the National Organization of Women started a Take Your Daughters to Work Day to introduce girls to the workforce and to equalize opportunities for girls and boys. Over many, many years, the Commission has embraced this concept, expanding it to Take Our Sons and Daughters to Work Day, opening up the workplace for all of our children to show them what we do and to show them career paths. Today, we are very pleased to be celebrating Take Our Sons and Daughters to Work Day, and we do have several children that are here joining us for a public meeting. Could you please stand?
Thank you. We welcome our youth that are here with us today, and we know that they will have an exciting day going around to our different bureaus and just finding out what the Commission does.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Commission's Bureau of Audits, commencing on page 1 of the public meeting agenda. It is recommended that the Commission adopt the recommendations of that bureau to make public the audit reports involving the First Energy companies, Metropolitan Edison Company, Pennsylvania Electric Company, Penn Power, and West Penn Power with regard to their default service rates. And on page 2, to make public the audit report regarding the National Fuel Gas Distribution Corporation's focused management and operations audit.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
On page 3 of the public meeting agenda, turning now to matters presented on behalf of the Commission's Bureau of Consumer Services, it is recommended that the Commission adopt the recommendation with regard to PPL Electric Utilities Corporation's Universal Service and Energy Conservation Plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Special Assistance, commencing on page 4 of the public meeting agenda. With regard to the first item, it is recommended that the Commission adopt the staff recommendation in the matter involving the Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company's accumulated deferred income tax.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
I have a statement Chair.
Commissioner Sweet.
Thank you. Before the Commission for consideration is a final order regarding the petitions of Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company, collectively First Energy, for approval of distribution system improvement charges, DISCs. The issue at hand in these proceedings is the impact, if any, of Act 40 of 2016 on the DISCs, specifically whether Act 40 requires the inclusion of accumulated deferred income taxes in the DISC calculation. The Office of Consumer Advocate, OCA, argues that the language of the Act is clear, that any rate, the DISC included, now must include income tax deductions and credits relating to an expense or an investment. First Energy argues that the language is ambiguous and that the intent of the Act was to address the use of consolidated tax adjustments in base rate proceedings. In reviewing the record in this proceeding and the recommendation before us, which would reverse the administrative law judge's decision in this matter, I find OCA's arguments persuasive and would affirm the ALJ's conclusion. I agree with the ALJ that the language of the statute is clear in its use of the word, quote, rate, unquote, and is free from ambiguity. Chapter 13 of the Public Utility Code addresses rate making generally, and the definition of the term rates is broad and includes but is not limited to base rates. Further, rate base is not the same as base rates. The reference, therefore, to rate base within 1301.1 does not render that section ambiguous with regard to its applicability to a DISC rate calculation, nor does it support the conclusion that the section is limited to base rate calculations only. If it was the intent of the General Assembly to limit this section to base rate calculations in base rate proceedings, they could have so specified. Therefore, an analysis of legislative intent per the factors of Section 1921C of Pennsylvania's Statutory Construction Act is not appropriate. I disagree with the recommendation before us today, which goes beyond a reading of the clear language of the statute, and therefore will be voting no.
Thank you, Commissioner Sweet. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
No.
The motion passes 4-1, noting the dissent of Commissioner Sweet.
Madam Chairman and Commissioners, we offer for your consideration the staff recommendation in the matter involving the complaint of Elchanan and Esther Abigail versus Philadelphia Gas Works.
Is there a motion to call off the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion. Any discussion?
I have a motion.
Commissioner Sweet.
Thank you. And I ask that my motion be placed upon the record as if I had read it in its entirety. This case comes to us, excuse me, on the exceptions filed by Philadelphia Gas Works, PGW, to the initial decision of Administrative Law Judge Angela T. Jones, ALJ, which sustained the formal complaint of the Abigails and found that the amount charged by PGW for theft of services was too high to reflect reasonable usage from January 2015 through November 2015. PGW filed exceptions, pointing out that the evidence relied upon was insufficient to support the burden of proof. I move that the PGW exceptions be granted in this instance because the evidence shows that the complainant admits to disconnecting the gas line and installing a bypass, that PGW was acting on an unbilled usage tip when a PGW technician found the bypass, and that there were 3 appliances hooked up to gas in the house at that time, and that PGW charged the complainant for unbilled usage from the date that the meter stopped showing usage to the date when PGW technicians found the bypass. These PGW actions were consistent with the utilities tariff and constituted reasonable service under the Public Utility Code. Accordingly, I move that the exceptions of PGW are granted, that the initial decision of the ALJ is reversed, that the complaint filed by the Abigails against PGW at this docket is dismissed in its entirety, and that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the matter as amended. Is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 5-0.
We will now recommend the adoption of certain matters altogether. As you know, we call that in omnibus fashion, commencing with the matter at the top of page 5 involving the complaint of the Bureau of Investigation and Enforcement versus Metro Transportation of Pennsylvania, LLC, TA Metro Taxi, continuing with the remaining item on page 5, as well as the 2 items on page 6, and the first item at the top of page 7, that being the complaint of the Commission's Bureau of Investigation and Enforcement versus Plymouth Rock Energy, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Motion by Commissioner Kennard. Is there a second?
Second.
Second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the staff's recommendation in the matter involving the petition for reconsideration of the Commission's order involving the acquisition by Aqua Pennsylvania wastewater of Limerick Township wastewater and its assets.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion?
Madam Chairman, I have a statement.
Commissioner Coleman.
Thank you. Prior to joining my staff, Philip Kirkner had worked in our Office of Investigation Enforcement, and this is a conflict statement this morning indicating that he has not advised me on this matter. Thank you.
Thank you. Any further discussion?
And not to be outdone, I have 2 statements, actually. The first is that Rachel Maurer, my staff, also worked on this case when she was in I&E, and she has not advised me in this matter at all. The second is a statement on the merits of this case. Act 12 of 2016 added Section 1329 to the Public Utility Code and established a clear legislative preference for municipal acquisition by private water companies. The General Assembly wisely gave the municipalities who could not or would not keep up with the developments and complexity of water and sewer regulations several options, including the option to sell at fair value. Various municipal systems are struggling and in need of all viable alternatives. I further agree with the clear mandate of the legislation that we should not be forced to wait for a system to become impaired before we can approve a fair valuation for the acquisition of that property. We've had 3 cases thus far involving 1329, and this one unfortunately failed. The one prior to that was settled. The one we voted on previously was approved at the purchase price. And what happened here is that the township's appraisal, there's 2 appraisers involved in this process, was so flawed, and it strayed considerable millions of dollars below Aqua's expert appraisal of $80 million and the purchase price of approximately $75 million. It's alarming to me that we have this divergence. One appraisal is saying it's worth 80, another saying it's worth somewhere in the mid 40 millions. And to me, that's a problem that we need to solve going forward. I know this commission as a whole is committed to fully and faithfully implementing Act 12, and I believe the solution here is to further define what adjustments are appropriate and provide color and depth to the USPAP standards. So in that regard, I believe the commission can and should establish a set of acceptable procedures, adjustments, and add-ins that will define the parameters of the appraisals. Voting here today, I believe, is consistent with the statutory intent of Act 12 to accept the township's appraisal because it complies generally with USPAP. And for that reason, Madam Chairman, I will be voting no on this.
Thank you, Commissioner Kennard. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed.
The motion passes 4-1, noting the dissent of Commissioner Kennard.
Turning now to page 8 of the public meeting agenda, we offer for the Commission's consideration the staff recommendation in the matter involving the Newtown Artesian Water Company's petition to increase the amount of money that it can collect pursuant to its distribution system improvement charges.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion. Any discussion?
I have a motion,
Commissioner Sweet.
and I would ask that my motion be placed upon the record as if I had read it in its entirety. In the case before us, Newtown Artesian Water Company, NAWC, seeks an increase to the distribution system improvement charge DISC cap from 5% to 7.5%. The Commission suspended the rate filing until May 1st, 2018. Following litigation with the Office of Consumer Advocate, Deputy Chief Administrative Law Judge Christopher Pell, he issued his recommended decision on February 9th, 2018, recommending denial of the proposal to increase the DISC cap from 5 to 7.5% of billed distribution revenues. NAWC filed exceptions and the OCA filed reply exceptions. After the record closed in the case, NAWC filed its DISC quarterly update, stating it had exceeded the 5% cap and that expenditures had already reached 5.44%. This information was not available to be included in the evidentiary record. Normally, we would not give a party more than one opportunity to prove its case. But in this instance, it appears that this information may prove to be relevant to the disposition of this matter. And as it has been filed with the Commission, we cannot pretend we don't have it, nor that we don't know about it. I note, too, that the quarterly update was served on the OCA, as the goal of the DISC is to facilitate infrastructure improvement and replacement. And this company is both willing and able to act responsibly to the betterment of its customers. I believe that the public interest is best served by giving the company an opportunity to address this issue one more time before the Commission makes its final decision on the case. It is, however, vitally important that this opportunity be accompanied by actions ensuring the due process rights of OCA. To that end, I move that NAWC be given an opportunity to voluntarily extend the rate filing suspension by 90 days by filing on or before April 27, 2018, an appropriate motion. And if it does, then the matter will be remanded to the Office of Administrative Law Judge for additional proceedings, limited to the single issue of whether the new evidence will justify granting the requested increase. If NAWC fails to file the voluntary extension, then the staff recommendation to deny the increase will be adopted. Therefore, I move that the exceptions of Newtown Artesian Water Company are granted in part, denied in part, consistent with this motion. Secondly, that the NAWC is permitted to file a voluntary extension of the rate filing suspension for a period of 90 days, and that said filing must be made on or before April 27, 2018. Third, if the Newtown Artesian Water Company files a 90-day extension of the rate filing suspension on or before April 27, 2018, this matter will be referred to the Office of Administrative Law Judge for proceedings consistent with this motion. If NAWC does not file a 90-day extension on or before April 27, 2018, the staff recommendation is adopted. And finally, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? Hearing none. The matter as amended passes 5-0.
It is recommended that the Commission adopt the Office of Special Assistance recommendation in the matter involving the joint petition for interconnection agreement of Arlington Telephone Company and Level 3 Communications, LLC.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Bureau of Technical Utility Services. Again, in omnibus fashion, it is recommended that the Commission adopt the recommendations commencing with that at the top of page 9 in the matter involving PPL Electric Utilities Corporation, continuing with the remaining items on page 9 as well as all items on pages 10, 11, and 12 through and including the recommendation involving the application of Clearwater Enterprises LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Law Bureau, it is recommended that the Commission adopt the recommendation involving the first matter, which pertains to the petition for reconsideration of a Commission order involving the Duquesne Light Company's Universal Service and Energy Conservation Plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
I have a brief statement.
Commissioner Sweet.
Thank you. In March 2017, the Commission evaluated a revised version of Duquesne's USEP plan for the period 2017 to 2019. I, along with Vice Chairman Place, introduced a motion which ordered that Duquesne begin a collaborative to address design issues in its Customer Assistance Program, CAP, specifically the energy burdens of those at or below 50% of the federal poverty guidelines. Duquesne worked with interested parties, including the OCA and the Coalition for Affordable Utility Services and Energy Efficiency in Pennsylvania, CAUSE-PA, to develop a cap that addressed the unaffordable aspects of their current plan. Together, the parties filed a joint petition on September 15th of 2017 to modify Duquesne's cap, in addition to requesting a waiver from Commission regulations that would have allowed the proposed plan to be effective through 2022. Earlier this year, the Commission approved, for various reasons, only the aspects of the proposed cap design that would be effective through 2019. Vice Chairman Place and I had a statement applauding the collaborative efforts that brought forth this consensus-driven plan. Yet at that time, we believed it was premature for Duquesne to make extensive policy changes given the open dockets regarding universal service and energy affordability. While I remain concerned about the timing of approving Duquesne's plan and have expressed similar concerns in other recent universal service proceedings that have proposed major policy changes, I am convinced by the points raised by CAUSE-PA in their petition for reconsideration. The interdependent and integrated nature of their 5-year plan, an outcome that developed over more than 6 months of meetings, negotiations, and planning by the parties, is, upon further reflection, to me at least, akin to a settlement agreement in my mind. And it should not be picked apart. Rather than upend these efforts, I'm inclined to support the implementation of Duquesne's 2-phase, 5-year customer assistance program on reconsideration. And I am reminded that the company, unlike other utilities, is in this unique position because of Commission action, which directed the kinds of changes defined in the company's revised plan. I would like to once again thank the parties for all their hard work in this proceeding. I believe these efforts will help inform this Commission as we move forward with our larger, more comprehensive examination of universal service and energy affordability. Thank you.
Thank you, Commissioner Sweet. Any further discussion?
I would associate myself with Commissioner Sweet's statement. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
We offer for consideration the Law Bureau's recommendation with regard to the implementation of Act 40 pertaining to solar photovoltaic systems and the Alternative Energy Portfolio Standards Act.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Under discussion, I do have a joint motion, and I'll turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of our motion. Chairman Brown.
Thank you. I ask that our motion be spread upon a record in its entirety as if I read it in its entirety. Before the Commission today is the Act 40 implementation order. Numerous stakeholders filed comments in response to the tentative implementation order adopted on December 21st, 2017. These comments have provided helpful guidance, and we thank all of those who took the time to help inform the record. Interpretation of sections 2402I and 2402II of Act 40 have been challenging for the Commission because the language in section 2402I is not precise. The question here is whether or not this statute is intended to grandfather out-of-state facilities certified before October 30th, 2017 to generate Tier 1 solar credits. Given this lack of clarity, the Vice Chairman and I issued a joint statement at the December 21st, 2017 public meeting offering a supplemental statutory interpretation to our comments. Because the statute was unclear and we are obligated under the rules of statutory construction to ascertain the intent of the General Assembly, the rules of the Statutory Construction Act at 1 PACS Section 1921 provide that when the words of a statute are clear and free from all ambiguity, the letter of it is not to be disregarded under the pretext of pursuing its spirit. When the words of a statute are not explicit, the intention of the General Assembly may be ascertained by considering, among other things, the circumstances under which it was enacted, the mischief to be remedied, the object to be obtained, the consequences of particular interpretation, the contemporaneous legislative history, and legislative and administrative interpretations of such statute. The comments filed in response to the tentative implementation order have proven instructive in regard to why the General Assembly drafted this legislation, why Governor Wolf signed it into law, and the mischief they were seeking to remedy. Comments were filed by the lawmakers who drafted Act 40 and by the governor. These commenters are uniquely qualified to provide the Commission with information regarding the intent of the statute. Each of the comments provided by lawmakers state that their intent to choose to close the borders for Tier 1 solar credit qualifications were consistent with the design utilized by a number of our neighboring states to promote economic development. The Department of Environmental Protection's comments stated that the intention of the statute were to provide certainty that solar PV facilities located within the Commonwealth would not be affected by the changes implemented elsewhere in Act 40. DEP stated that the interpretation outlined in the tentative implementation order would essentially nullify the purpose of Act 40 by grandfathering enough currently certified services or sources to prevent the law from having any environmental benefit whatsoever. Commenters also noted that if the legislative intent of Section 28042I follows the interpretation outlined in the tentative implementation order, there would be no need for the additional language of Section 2804II to further protect existing facilities that have entered into agreements with Pennsylvania EDCs and EGSs. Therefore, the language of Section 28042II is evidence that the legislative intent of Act 40 of 2017 is to stimulate further investment in solar facilities within the Commonwealth. The rules of statutory construction as well as case law both state that for purposes of statutory interpretation, the General Assembly intends the entire statute to be effective and does not intend words to be mere superfluous. Our review of the text of the statute as well as the comments filed at this docket have led us to interpret Act 40 as follows. Section 28042I, we interpret the phrase a certification originating within the geographical boundaries of this Commonwealth as a facility located within Pennsylvania having received an AEPS Tier 1 solar photovoltaic share certification. Section 20042II, we interpret this section to permit out-of-state facilities that are A, already certified as AEPS Tier 1 solar
I cannot pronounce that word for the, I'm going to skip over that. And that I'm going to skip over that. Have entered into a contract with the Pennsylvania EDC and EGS serving Pennsylvania customers for the sale of solar credits to maintain certification under the expiration of the contract. This maintained certification is only applicable to the amount of the credits contractually committed to by an out-of-state certified facility to an EDC or EGS. Given these interpretations, we now turn to the treatment of the banked credits. The AEPS Act permits EDCs and EGSs to bank credits produced in one reporting year for compliance in the next 2 reporting years. Because the Statutory Construction Act does not presume retroactive effect of statutes, and because Act 40 did not direct the commission to modify the value of bank credits, we believe that these credits should retain the tier attribute assigned at the time the credit was generated. Within this order, we begin the process of implementing Act 40 while recognizing that there are complexities in implementing and complying with the Act that may reveal issues which require further commission action. The commission will address any such issues at this docket and in a manner that provides all interested parties appropriate notice and opportunity to be heard. Therefore, we move that, 1, the electric distribution companies and electric generation suppliers seeking to qualify credits under Act 2804 of Act 40 are required to file a petition within 60 days of the entry date of this order, the specific procedures for which will be outlined at this docket. And 2, the Law Bureau and the Bureau of Technical Utility Services prepare a final implementation order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion?
I have a brief comment. I want to encourage all the parties to work with the commission staff in ensuring that the contract review of solar, that's the word I have a problem with, solar renewable energy credits is done correctly, expeditiously, in a manner that ensures the uninterrupted implementation of Act 40 along with our obligations under the AEPS Act. In the event that our jurisdictional EDCs and EGSs have reason to believe that there will be a shortage of SRECs so as to impede our obligations under the AEP Act, we urge those parties to promptly notify the commission and work with the staff to overcome such potential challenges.
Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0. Gavel is yours, Chairman.
Thank you. Is there any objection to taking the previous roll call in terms of the matter as amended? Hearing none, the matter as amended passes 5-0.
And now turning to matters presented on behalf of the Commission's Office of Administrative Law Judge, we're on page 14 of the public meeting agenda. It is recommended that the Commission adopt Deputy Chief A.L.J. Hoyer's recommended decision in the matter involving Norfolk Southern Railway Company and the Borough of Girard.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
We offer for consideration A.L.J. Dunderdale's initial decision in the matter involving Vertus Dillon versus UGI Utilities, Inc.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion, I do have a motion, so I'm going to turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you. I ask that my motion be spread upon a record in its entirety. Before the commission today is the complaint of Vertus Dillon filed on January 9, 2017 concerning an arrearage and identity theft. UGI, Penn National Gas, or PNG, denied the allegations. A telephonic hearing was scheduled for April 21st, 2017. On April 18, 2017, a counselor for the Lackawanna County Prison notified the Office of Administrative Law Judge that the complainant would not be able to appear telephonically because he was incarcerated. The hearing was held on April 21, 2017. The complainant did not appear. PNG's counsel moved for dismissal. The complainant repeated that he could not participate in a hearing and repeated a request for a hearing. Section 5.245B of our regulations provides that dismissal for failure to appear is not applicable if the failure to appear is unavoidable. In this case, failure to appear was unavoidable due to the internal rules of the prison, which preclude complainant from telephonic participation. Accordingly, this matter should be remanded to the Office of Administrative Law Judge for them to make a reasonable attempt to locate Mr. Dillon. If the Office of Administrative Law Judge is successful, then the Office of Administrative Law Judge will work with his counselor to schedule a telephonic hearing. These efforts should be memorialized and put a memo placed in the record. If the Office of Administrative Law Judge's efforts fail to locate Mr. Dillon, then the ALJ can author an initial decision on remand, which dismisses the case. Therefore, I move that the initial decision of the Administrative Law Judge, Judge Katrina Dunderdale, is reversed. 2, that the matter is remanded to the Office of Administrative Law Judge for proceedings consistent with this motion. And 3, that the Office of Special Assistants prepare an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion?
Vice Chairman Place, I have a statement on this matter.
Commissioner Coleman.
I'd ask that my dissenting statement be placed on the record as though I read it in its entirety. In the matter before us today, Vertus Dillon, as you've heard, has filed a complaint with the Commission claiming that UGI incorrectly charged him for services while he was incarcerated. After he filed the complaint, but before the initial hearing, Mr. Dillon was again reincarcerated. So in essence, what Mr. Dillon is asking is that the charges for utility services while he was incarcerated at his address be removed from his bill. After being informed of this, the Administrative Law Judge, Judge Dunderdale, in this proceeding took substantial steps to try to accommodate Mr. Dillon despite his incarceration. Motions had to be made in writing and sent to Mr. Dillon in prison. Month-long continuances and delays were given on Mr. Dillon's behalf despite no contact from him. Multiple orders and letters were sent to him asking what the Commission could do to allow him to put this case on. In my view, Judge Dunderdale went above and beyond the call of duty in this case in trying to accommodate Mr. Dillon. Mr. Dillon has not responded since May 1st of last year, despite the evidence of receiving letters, yet today the Commission overturns Judge Dunderdale's dismissal and sends the case back to the exact place where it was nearly a year ago. Due process concerns don't require hearing, but instead require the opportunity to be heard. Mr. Dillon has been granted many opportunities to be accommodated and to be heard at the expense of the Commission staff, UGI, and UGI's expert witnesses. It is my opinion that ALJ Dunderdale acted reasonably in this matter and that it is improper to remand this matter back to the ALJ. I believe that Section 5.245 of the regulations do not excuse the failure of the complainant to take any involvement in his own case, and I believe that the ALJ provided this complainant with multiple meaningful opportunities to be heard. Therefore, I will be dissenting this morning.
Thank you.
And I too support the ALJ and wish to associate myself with Commissioner Coleman's comments.
Thank you, Commissioner Kennard. I wish to associate myself with the chairman's motion. From the facts of this case, the ALJ and parties were fully aware that this complainant may not be able to participate in a telephonic hearing because of the incarceration. I believe that the Office of Administrative Law Judge has the expertise to work with this commission in order that he be provided the due process at this stage in this proceeding. Thank you. Seeing no further discussion, all those in favor signify by saying aye.
Aye.
Any opposed?
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 The motion carries 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman. Chairman, the gavel is yours.
Thank you. On this matter as amended, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman.
It should be noted that the next item appearing on the agenda, that pertaining to the complaint of Eugene A. Haggard versus Philadelphia Gas Works, has been postponed until the next public meeting, which I believe is May 3rd. Continuing to page 15 of the public meeting agenda, we do offer for the Commission's consideration the recommendation of ALJ Johnson in the matter involving the annual rate increase request of the Pine Row Natural Gas Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. And any discussion?
I have a motion.
Commissioner Sweet.
And I would ask again that my motion be placed upon the record as if I had read it in its entirety. In this matter, the recommended decision of the ALJ is to approve without modification a joint petition for settlement of a base rate case and the Office of Consumer Advocate, the OCA's formal complaint against the base rate filing. While I have no desire to modify the terms of the settlement, which represent earnest and diligent efforts on the part of the ALJ, the OCA, and the Commission's Bureau of Investigation and Enforcement, there is a matter raised in the recommended decision that requires clarification. As Pine Row is a corporation, it must be represented by counsel in an adversarial proceeding. To hold otherwise would potentially run afoul of the Pennsylvania Supreme Court's strict ban against the unauthorized practice of law. Our regulations state that a base rate case is considered to be adversarial. Because that statement in our regulations is a general commission finding and is not based upon a legal mandate, we can waive that part of this regulation where warranted. Under the very limited circumstances, such as those presented here, where the utility is very small, where the settlement has been managed under the vigilant eyes of both OCA and I&E, which has already taken the utility to task in a prior complaint case, and the utility is still bound by the agreement to improve its performance there as well, a waiver is warranted. In future adversarial cases, however, Pine Row is warned that this limited waiver may not be available, and the standard requirement that it obtain legal counsel will be enforced. Therefore, I move that the recommended decision of the administrative law judge is adopted as modified by this motion, that the Commission's regulations at 52 PA Code 1.21b, stating that the filing of a base rate case is an adversarial proceeding, is waived under 52 PA Code 1.91. And thirdly, that the Office of Special Assistants prepare an order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 5-0.
Madam Chairman and Commissioners, that does conclude the regular agenda presentations. Turning now to the carrying agenda. It is recommended that on behalf of the Commission's Bureau of Technical Utility Services, the Commission adopt that Bureau's recommendation in the matter involving the annual increase in distribution revenue of PECO Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And that concludes the presentation of carrying agenda items, Madam Chairman.
Is there any additional matters to come before us today?
Yes, Madam Chairman, it is with great pride and congratulations that I would now acknowledge Vice Chairman Place for purposes of moving into the your swearing in for another 5-year term as a commissioner on the Pennsylvania Public Utility Commission.
Thank you very much. It is also my honor to preside over the swearing in of Chairman Brown. Please welcome Acting Secretary of State Robert Torres, who's joining us here today for the swearing in. Good morning. Joining Chairman Brown today are her sisters, Emma Pettis and Florence Abdullah, as well as holding her Bible for the treatment is her boyfriend, Steve Shrell, who's also here with us today.
Okay, good. Place your left hand on the Bible. Raise your right hand. Repeat after me. I state your name.
I, Gladys Marie Brown,
Do solemnly swear
do solemnly swear
to support, obey, and defend
to support, obey, and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the Commonwealth of Pennsylvania,
and the Constitution of the Commonwealth of Pennsylvania,
and that I will discharge the duties of my office
and that I would discharge the duties of my office
with fidelity.
with fidelity.
Congratulations.
Thank you very much.
Congratulations. Congratulations.
We're going to take a quick picture of us.
Yep. And I have your commission. Sign right there.
As the chairman is signing the documents, and consistent with another tradition of the Pennsylvania Public Utility Commission, we would call forward, please, Ms. Gabriella Crum-Ewing to bang the gavel to close out this public meeting. Gabriella?
We'll take a moment first before we gavel out. I'd like to just make a few comments. First of all, to thank everyone that is here for this special day for me. As you know, 5 years ago, I came from the Senate of Pennsylvania, the Democratic caucus, as a counsel who worked on so many different utility issues, and it was truly my honor to be given the opportunity to serve here on the commission then, and I am so grateful to Governor Wolf for the nomination to serve again for another 5 years. It has been such a great pleasure to be able to work with all the staff here at the PUC, especially my personal staff that is here today. It's because the staff makes us look good in terms of the job that we do. I can also say it's been a great pleasure to work not only with those commissioners that used to serve with me, but also those commissioners that are sitting here on the bench with me today. I think we all bring our own gifts and talents to this job, and with that, we are very fierce and passionate in what we're trying to do here at the commission in terms of protecting the consumers that are provided the public utilities, and also providing that balance to the public utilities that we regulate. So I thank the commissioners that are serving here with me today, because I know that we have a big responsibility ahead of us, and we will continue to do all the work that we are charged to do, and we will take all that passion that we show each and every time. As you've seen the different motions and the comments that you've seen here today, they are legitimate. They are coming from the heart from all of us. So I just want to thank all the commissioners that I serve with today, and thank my family that is here and my friends as well. And I know I have some sorority sisters there in the back. I can't forget my sorority sisters, but I just want to thank all of you, because I know throughout my year, my family has been so supportive of me with all the different things that I've had to do, and I just want to thank them and tell them how much I love them as well. So thank you very much.
Who's standing up? Who's standing up?
I would add my own personal congratulations. It has been an honor to serve with Chairman Brown, and it will be an ongoing honor to serve moving forward. This is valuable work that goes on here throughout the commission, and Chairman Brown's being absolutely fundamental leader in the work that we do here. So again, congratulations on my
Thank
behalf.
you.
If I might, even though I probably have used up more than my quota of airtime in this meeting and was chastened a bit for it previously, I can't pass up the opportunity to say a word or two about Gladys and my real happiness and fervent desire to continue to serve with her as the chair. I can say that when I went on my sojourn over in the Capitol and visited senators, her former employers, I got questions about all kinds of things. The only thing that generally related to the Public Utility Commission, quite frankly, was not so much a question, but an admonition that I was not to disrupt the very clear, precise leadership that Chairman Brown was providing, that I should just go over there and do my job and listen to what she told me to do. And on occasion, I've done that, I think. On occasion, I've not. But as chair, and let me just make this final comment, as chair, Gladys is really the public face, the public voice of this commission. And it's not easy to represent this five-headed monster. She does it with great style, with eloquence, with patience, and with sort of a fervent desire to do what is right. And I am proud, honored, and humbled to be one of the five that she represents out there in the public. And I've had no better person stand in my stead over the years. And I can just assure you that her former employer over in the Capitol that for 22 years was well served. And Gladys and I have another link. She and her clerkship worked for now deceased but former U.S. District Court Judge Paul Simmons. And I knew Judge Simmons well. He was a colleague of my father's on the Common Pleas bench in Washington County a few years ago. I'll dwell on it, but I know that Judge Simmons was a very good lawyer and a very good judge, and it's obvious that Gladys was well trained in that role as well. So thank you very much for your service, and I look forward to now. I think I have 3 more years of attempting to follow your lead as best I can.
Thank you.
If I may, I've had the pleasure of serving with Gladys for the past 5 years, and I'm looking forward to an additional 5. But I do want to share one personal note for those of you who know Gladys, and you can see today you're beaming. And there's also a sigh.
Is it? I don't know.
There's also a sigh of relief that that those of you who know Gladys, that there has been some level of anxiety leading to this point of a renomination and a confirmation. And in my mind, it was never in question. This was a slam dunk, in my view, from the beginning to where we are today. I never questioned the thought that Gladys would not be renominated and unanimously confirmed by the Senate. So rest assured, we're ready to move forward, and you can breathe a sigh of relief. And I just want to comment one other point on something that Commissioner Sweet had mentioned, that it is not an easy job as chairman. And I just want to underscore that point, that the chairman is the voice of this commission and is usually the face of this commission. And I've got to say that she does a tremendous job in representing us, not just here in Harrisburg and not just across the state, but around the country. And we are well respected and well represented in her leadership. So thank you, Gladys.
Thank you, Commissioner.
It's always hard to follow the eloquence of the bench up here. But I think the most eloquent thing that happened today was a double standing ovation. I don't know if I've ever seen that. And it really is in reference to the view in which we hold you, the appreciation we have for what you do, the way that you handle yourself and lead us forward. And because Commissioner Sweet says sometimes we follow, sometimes we don't, but we always listen to you because you provide wise advice and good leadership. So it gives me great pleasure to congratulate you on your well-deserved second term. You are a treasure in the state of Pennsylvania, and you are increasingly doing more and more work at the federal level through our compatriots at NARUC, and I wish you the best in that as well. So I'm delighted to be working with you and look forward to the next 5 years, Gladys.
Thank you.
Chairman, it's an honor to return the gavel to you. Gavel's yours.
Thank you very much. First of all, thank my colleagues for those very kind words. And yes, we do have a lot of work to do, and I know that we're all up to the challenge. Before we do close out, we do have some words from Commissioner Coleman on Safe Digging Month.
Well, it's really hard to follow that. And I'll
Don't expect a standing ovation.
Thank you very much. As many of you have been with us over the years, it's usually my privilege and honor to announcing Safe Digging Month, and I do so again today. Just a couple of quick reminders on this. This is really a safety matter that is paramount to this commission, and we have been working on a couple of changes to the one-call law that would bring that enforcement within this organization. And I know I have promised and pledged to you that we will get to the finish line at some point in the future, and I'm delighted to tell you that we've gotten there. With Act 50 being enacted and signed by the governor, that enforcement responsibility is coming to this organization. And it is for good reason. What we're talking about here is a very serious matter. This is typically third-party contractors that are excavating and are hitting utility lines across the state of Pennsylvania. In fact, they're doing it at a rate of over 6,000 hits, a year. So while we've been sitting here in this room for the last hour, there have been 3 line hits somewhere in the state of Pennsylvania. And some of those may come with very little consequence, that it is a water line in somebody's neighborhood that has interrupted service with a neighbor. And some of them are catastrophic and lead to fatalities and interruption of service. So it is of critical importance that we take on a role of increased enforcement in one call to reduce those line hits. Everybody wins in this. If you are the owner of those facilities, you win by not having to go out and repair those lines and not having interruption of service, and the safety for your workers. If you are a property owner, a homeowner, a business owner, this is also good for you, that you don't have the interruption of service or, again, these safety matters that are concerned with somebody hitting a line in your neighborhood. If you're an excavator, you certainly don't want to put yourself or your employees at risk by going into the field and finding that lines are not marked correctly and hitting a line that, again, can have catastrophic consequences. So again, I'm delighted to recognize Safe Digging Month, and I also want to commend and thank Governor Wolf for the proclamation on Safe Digging Month, and I just want to take a minute and read a couple of the whereases in his proclamation that I think are important here this morning. And it says, whereas excavators and homeowners work to keep pace with the Commonwealth's economic development, and as they do so, it is important to minimize damage to underground utility lines, danger to workers, threats to the environmental pollution, and the loss of utility service. And whereas each year, the Pennsylvania One Call system receives more than 750,000 incoming notifications and transmits more than 6 million notifications to utility companies to mark their facilities in the field, safeguarding utility companies, their employees, and their companies. Whereas the Pennsylvania Public Utility Commission worked in collaboration with the Pennsylvania legislature to craft and approve legislation focused on enhancing a statewide effort to reduce the number of hits of underground utilities, infrastructure, and better safeguard the public. So I want to thank the governor for that proclamation, and want to thank all of you for your attention this morning, and ask that you be safe out there if you are excavating. Thank you.
Thank you, Commissioner Coleman. So as we are about to close out, let me just thank again all of you for coming to our public meeting. I know this was a special one. I'm just very grateful for my family and friends and former colleagues in the Senate that came, and sorority sisters. And I also have to mention that I see my pastor and his wife sitting in the back there, Reverend Bragman. So I want to thank them also for coming. So now to close us out, because we know we have a lot of youth here for Daughter and Sons Day, is Gabriella Crum Ewing. And we usually take this opportunity to allow one of our youth to gavel us out. So if there is no objection to an adjournment, Gabriella, the gavel is yours. We are adjourned.